The judge starts with something brutal. This isn't about efficiency, it's about power. The constitution was designed to slow things down, and the government treated those limits like obstacles. So what did they do? They didn't remove the rules, they redesigned the structure. They took one Senate-confirmed office and split it into 3 people and triumvirate. But if each of those people still has final authority, then you didn't reduce the power, you cloned it. And this is where everything that looked theoretical turns real. The moment that went viral didn't came from a memo, it came from a live federal courtroom during a sentencing hearing involving independent Francisco Villafane. So now this isn't a theory anymore. This is about whether the government can stand in the court and exercise real power. And the judge, Zahid Qureshi, locks onto one question: who is currently running the U.S. Attorney Office for a district of New Jersey? Even the Department of Justice's own official announcement, the leadership authorization page, becomes part of that question. Because once that question is asked in the court, everything shifts. But this is where the structure starts breaking in real time. The prosecutor handling the hearing is pressed on leadership and authority, and according to transcript-based report, including detailed coverage from a Bloomberg Law, the answer fall into a pattern. I don't have a personal knowledge. Now stop there, because in any context that sounds careful. Here it's devastating. You have a federal prosecutor standing in a court representing the authority of the United States, and when asked who is actually in charge of that authority, the answer is I don't know. That's not caution, that's exposure. And the judge immediately recognizes what that means, because from the court's perspective, this is no longer a routine proceeding, this is a breakdown in the authority. So the tone shifts. The judge starts interrupting, cutting off answers, they don't just resolve the issue, and then it escalates. As reported by the Associated Press, the judge tells the DOJ official in substance, "You're not here to talk. If you keep speaking, you will be removed. And you don't get to blindside the court." This is not normal courtroom language. This is a judge asserting a control over a system that is sleeping. And then the moment happens. The warnings don't land, the interruptions continue. The judge follows through. He orders a DOJ official to leave a courtroom or be removed. This is reflected in transcript-based reporting, including a Bloomberg Law coverage of a hearing. Just understand how rare it is. Federal courtrooms operate on a structure and discipline. For a judge to eject a government lawyer mid-proceeding, that's not a frustration. That's a resistance. But this moment doesn't happen in isolation. It detonates because of what's underneath it. This entire courtroom clash sits on top of a long-running legal fight over how the Department of Justice has been staffing and the U.S. Attorney Office in New Jersey without going through a normal confirmation process. So when a judge asks who is actually in charge, that's not curiosity, that's pressure. Because every prosecutor who appears in a court is implicitly asserting lawful authority. If that authority is under legal cloud, everything becomes unstable, and then it gets worse. Because this isn't a low-stakes case, it involves a child sexual abuse material, and the judge is already criticizing how the government is handling it, including negotiating a plea agreement before forensic review was complete. So now you have 2 pressures converging. First, the authority under question, and second, which is a prosecutor decision under question. And at the same time, the office is facing scrutiny in other areas, including reports that federal court orders were violated dozens of times in immigration-related cases in the same district. That's not just tension, that's credibility collapse. Normally, authority is assumed and the proceedings move forward. Here, the authority becomes the issue and everything stops, because once leadership is unclear, every action taken by that office becomes vulnerable. So when the judge asks who is running this office, he is not asking for information, he is testing whether the case can even proceed. And just days before this hearing, the situation had already escalated further. Another federal judge rules that this leadership structure violated both federal law and the Constitution and disqualified the officials involved. And in that opinion, there is a line that hits directly onto this moment. A state cannot validate an unlawful appointment at its own risk. That line matters because it means even if enforcement is paused, the underlying problem doesn't disappear. And this is why it lands so hard, because what looks like a courtroom clash is actually the visible edge of a much larger conflict. Who controls the prosecutorial power and whether that control can exist outside the Constitution? And this is the most important part. It doesn't end here, because after this hearing, the judge orders the office leadership to testify under oath about who is running the office and how that power is being exercised. So now the question becomes formal, sworn, on the record, unavoidable, and that is where everything starts to unravel. The judge starts by doing something very deliberate here. He he refuses to treat this like a technical paperwork dispute. He says the Constitution was designed to ease friction on purpose. In other words, delay is not a bug and limits are not a defect. And the whole point is to stop one branch from quietly absorbing more power than it's supposed to have. And then he turns directly to this administration and says in substance, you are treating those limits like obstacles to be engineered around. And that's a real setup. The government position is not just we found a practical solution. The government position is even though the Senate confirmation has been required for this offense for more than a century, the Attorney General can somewhat appoint other people, give them real power, and pretend that nothing constitutionally meaningful has happened. That's why the judge says this case is about power, not etiquette, not efficiency, power. And then he lands that line that makes just the page so little. The government dresses this up as administrative necessity, but this wolf comes as a wolf. And that's not a subtle language. That's a judge saying, I see exactly what this is. They didn't just remove the confirmation requirements. They tried to step around it. Same power, different label. And that's the trick. And once you see that framing, the next move becomes a lot easier to understand. After Alina Habba resigned, the Attorney General didn't just resolve the problem by following the ordinary appointment path. Instead, she split the office across 3 people: Philippe Lamparello over criminal and special prosecutions, Jordan Fox over civil and appellate matters plus everything else not specifically delegated, and Ari Forteccio over administration. And the opinions calls the structure the triumvirate, and that word matters. This is not just a colorful. It tells you the judge thinks this is not just normal chain of command, but a constructed power-sharing arrangement. And the deeper problem is that this was not a true division of power in any limiting sense. Government confirmed these 3 people had autonomy to make a final decision with their own spheres. So the defense theory here is almost just embarrassingly thin. They want you to believe that if you carve one powerful office into 3 slices, the constitutional problem somewhat gets smaller. But if each slice still carries final authority, then the problem did not shrink, it multiplied. And one Senate-confirmed office holder gets replaced by 3 unelected substitutes with parallel power. And that's not restraint, that's a duplication. And they could not just lawfully keep one person in charge, so they built a 3-headed version of the same thing and hoped the new shape would just distract from the old problem. But this is where it gets worse, because the government did not just get to hide behind necessity. On page 8, the judge says the government explicitly conceded that this Rube Goldberg-style delegation mechanism was not necessarily to keep the office running. That admission is devastating, and it destroys the most sympathetic version of their case. If they had no other option, they could at least argue emergency, but this is not what happened. The court says there was at least 3 undisputedly legal methods immediately available to fill the office and move forward lawfully. So now the logic changes completely. Once multiple legal options were sitting right there on the table, and the government still chose the most tangled, artificial, unstable workaround, necessity is gone, and what remains is preference. They didn't just build contraption because they had to. They built it because it gave them a form of control they just liked better. And this is why Rube Goldberg style hurts so much here. It's not just a joke, and it's the judge's way of saying this thing is just over-engineered because it's trying to achieve indirectly what the law would not just permit directly. And they built a complex workaround for a problem that didn't just actually exist. And then opinion widens the aperture, so the judge asks the question that should make just every prosecutor in the district nervous with legal options still available. Why does the fate of thousands of criminal prosecutions potentially rest on this unprecedented and Byzantine leadership structure? And then he gives the answer the government itself effectively supplied. The president does not just like that. He cannot simply appoint whomever he wants. Notice what the judge is doing there. He is no longer talking about the legal form. He is assigning motive, safe path available, lawful path available, faster cleaner options available, yet rejected. Why? Because limits were unacceptable. That transforms the case from maybe they misread the statute into they knowingly just choose a riskier path because they preferred control over legality. And the stakes are not abstract. The court is openly warning that scores of dangerous criminals could ultimately have their cases dismissed or convictions reversed if the authority problem is sealed. So this is not some academic separation of power seminar. This is the judge saying your choice to chase unilateral control may blow up actual prosecutions in the real world. And they didn't just ban the rules. They put the entire entire case is at risk. And this is the part that changes everything, because the opinion makes it clear that this is not isolation to New Jersey. The judge says the same vacancy pattern appears in at least 5 other districts, with offices being run through delegations to people chosen unilaterally by Attorney General and President. The defense can no longer pretend this is one of just local improvisation. The court is identifying a broader pattern. Then comes the proof of concept. In 2 districts, the judges used their statutory power under Section 546D to appoint United States Attorney lawfully. And what happened? They were fired within hours. That sequence is devastating because it strips away every software explanation. This is not about efficiency. It's not about administrative convenience. It's not about temporary confusion. A lawful correction mechanism was actually used, and it was neutralized almost immediately. And that means the problem is not that the executive branch lacked options. The problem is that it rejected options it could not just fully control. And every time the system tried to correct itself, the correction got overridden. And that point, calling this workaround is too generous. This is a power struggle. And then the judge turns from pattern to conclusion, and the language gets even sharper. And he knows that public statements from Deputy Attorney General Todd Blank made the administration position unmistakable. So the Department of Justice will not permit anyone to hold any United States Attorney office unless that person was handpicked by the president. And after laying out just the removals, the post, and the surrounding contact, the judge says it's crystal clear and not capable of factual dispute that government conduct here is intended to fill the office unilaterally. And that phrase matters. Crystal clear means he thinks the inference is obvious. Not capable of factual dispute means, in his view, this is not even a close call. And once he says that, he does something just even more damaging. He says he will ignore any argument based on practical need to operate the office. In plain English, the government loses the right to hide behind functionality because the court has already concluded this is really about unilateral control, and that is an absolute brutal move. The law gave them a mechanism. The court used it, and the executive branch undid it. And then it claimed necessity, and the judge essentially responds, no, I'm not entertaining that fiction anymore. When judges appoint U.S. attorneys and they get fired within hours, the issue is no longer administration. The issue is who gets to own prosecutorial power. And by the time the opinion reaches the merits section, the judge has already done the real war. He has framed the motive, exposed the workaround, and rejected necessity. So pages 21 and 22, like a formal detonation. He says he will answer 3 questions: whether to use a triumvirate as a whole, how much power was actually delegated, and where that power supposedly came from. And that is a classic judicial compression. He's telling you the whole dispute comes down to structure, scope, and source. And then he delivers a holding. First, the Federal Vacancies Reform Act prohibits the current leadership structure. And second, the appointment clause also prohibits the government's conduct. And that's a double kill, because statutory failure and constitutional failure. So even if one theory somewhat weakened, the structure still collapses under the other, and then comes the consequence. The triumvirate is acting unlawfully. Both defendants are entitled to disqualification, and Navivala's case survives for now, and a jury dismissal motion needs more development because his indictment traces back to authority exercised by the prior office holder. And that's not the court saying that this was a problematic. That's the court saying the structure crossed the line and the remedy is real. After all the engineering, all the relabeling, all the attempts to turn delegation into substitute for appointment, the judge hands in the simplest possible place. The arraignment is unlawful, not awkward, not debatable, unlawful. And that is really the final lesson of this opinion. The government's entire strategy depended on one premise, that if it changed the titles, split the duties, and built enough procedural scaffolding around the arraignment, it could exercise real power without triggering the same constitutional consequences. And the judge rejects that premise from start to finish. He looks past the labels and focuses on reality. Who is exercising the power? How was that power obtained? And was the ordinary constitutional path deliberately bypassed? And once those questions are asked honestly, the rest of the structure starts looking less like a solution and more like an evidence of a branch trying to keep control of powerful office without accepting the constraints that come with it. And that's why the opinion hits so hard. It's not just criticizing a bad legal theory, it's exposing a government instinct when the rules get in the way, so redesigning the machinery until it looks like a compliance. And the court's answer is simple: no. You do not get to recreate a Senate-confirmed office by clever delegation, then act surprised when constitutional still notices everything the judge warned about in the opening pages turns out to be exactly right in the end. And this was not administrative convenience. It was a power grab that crossed the line. And here's the part most people miss. This case is not really about New Jersey. It's about a much bigger question. What happens when power doesn't want to wait for permission anymore? Because look at the pattern. The rules exist, the lawful path exists, the constraints are clear, and instead of following them, the system gets redesigned, adjusted, relabeled until it looks compliant. But once a court actually stops and asks who is really in charge, everything starts breaking, not slowly, not rhetorically, immediately. And that's why this moment went viral, because it wasn't just a judge getting frustrated. There was a judge forcing the system to answer a question it was clearly not prepared to answer. And when the answer becomes, I don't have a personal knowledge, that's not caution. That's collapse. Now the real question is not what happened in that courtroom. The real question is how many other cases are built on the exact same structure. Because if the authority is unstable, then everything built on top of it becomes just unstable too. Charges, convictions, and entire prosecutions. And this doesn't just end here, because the court has already ordered sworn testimony under oath on the record, meaning the next phase of this story is not speculation, it's exposure. And if the structure really is unlawful, then this isn't just a bad workaround, it's a system that keeps operating while knowing it might not have the authority to exist. And that is where this stops being a legal story and starts becoming something much bigger. If you want more breakdowns like this, not headlines, not opinions, but actual filings, actual transcripts, and what they really mean, subscribe. Because this is exactly the kind of case that doesn't just go anywhere, it expands. And I will be tracking what happens next.